Tonight we continue our coverage of the ConCourt judgment on former President Jacob Zuma with reaction from former public protector, that is Professor Thuli Madonsela will be joining us shortly. But right now we are joined by Neeshan Bolton from the Ahmed Kathrada Foundation. Neeshan, good evening and thank you very much for joining us tonight.
Good evening and greetings to your viewers.
Neeshan, what do civil contempt proceedings serve in a society as far as you're looking at it?
Well, essentially what this means is that if you're compelled to comply with a court order, for example, having to go and give testimony at a commission or to attend court proceedings, and you choose to defy that, it essentially could render the entire court system and your criminal justice system non-functional if there is that kind of mass defiance, and if this precedent had not been dealt with in the way in which it was done, then that kind of precedent would have really created mayhem in our criminal justice system.
Yeah. This has brought on a debate that this particular matter was about a choice between the upholding of the rule of law and the protecting of the rights of an individual, this time former President Jacob Zuma. Did the courts manage to strike that balance correctly as far as you're concerned? And of course there is a minority judgment here where Judge Theron, for example, raises a question of the constitutionality of a custodial or a committal order in this particular
now with Africanism, Africa automatically. Sorry, I forgot.
Apologies there. That is the public protector, Professor Thuli Madonsela, coming into the conversation. Neeshan, I was asking the question, is that debate valid, that this particular matter has become about whether or not the courts went too far in upholding the rule of law and ended up rubbing up against the rights of former President Jacob Zuma?
No, well, former President Zuma chose not to represent himself in court, chose not to present his side of his own story, chose not to defend himself in any way. So, I mean, I think that is what must be taken into account, that he chose not to do that as most other people would do, and thereby then accept the outcome of the proceedings. I think, secondly, the custodial sentence is a view of the majority of the Constitutional Court members, who essentially had to weigh up all of the issues, and I think ultimately found what, in our view, is perhaps the most lenient possible sentence that they could have served, as an indicator of its seriousness. And as I think that the judgment reads, the sentence, in fact, does not mitigate against the amount of damage which the court thinks has been done not only to the integrity of the court, but to our constitutional democracy. So I think that they were spot on. This is possibly the most lenient sentence that could have been given, but the judgment is scathing about the behavior and the attitude of the former president to a process which he, in fact, promulgated all of the rules and regulations that govern it.
Professor Madonsela, good evening and thank you very much for your time as you're coming in here. We are, of course, expanding on that particular matter that's been raised also by the minority judgment on this matter. Judge Theron raising the question of the vindication of particular facets of the rule of law, seemingly in this particular instance running up against the procedural rights of former President Jacob Zuma. What's your take on that?
Good evening. Thank you for the privilege. I do understand where Judge Theron comes from, because in the process of judging, you have to balance. In this particular case, the Constitutional Court had the unenviable task of balancing public good, public interest, with the personal circumstances and interests of President Zuma. And in looking at his personal circumstances and interest, they considered what else could have been done to ensure that there was accountability. The majority judgment, on the other hand, took into account the fact that President Zuma has been defiant of this process. He, as my colleague Sean has indicated, he did not even accept an opportunity to engage with the Constitutional Court on this matter. And therefore, they looked at what more damage could be done to the rule of law and the judicial system as he would continue to assail it with no interest of real and meaningful engagement on this matter. And that damage would then go beyond this matter. It would erode trust in the entire judicial system. And in the process, democracy, as Adam Smith said, would crumble.
Now, of course, the scandalous remarks that the former president made also, I suppose, led to the courts leading to this quite severe punitive order. But why did the court, I mean, let me just say, had the court gone for a less restrictive measure, what would that have really meant in society? And maybe go for coercion and say, well, if this time you don't comply, then you're going to jail.
I must indicate that I haven't considered all considerations that the Constitutional Court made. I do think, though, that at the core of the decision was the seriousness of was the seriousness of former President Zuma's actions. So on the one hand, the court had to have empathy with him, walk in his shoes. But on the other hand, it needed to come up with a sentence that has a real deterrent effect on anybody who would like to ignore judgments or orders of any court, but in particular the apex court of the land.
How does this limitation, Neeshan, for example, benefit the commission? Because it is, of course, the commission that initially brought this case on to the Constitutional Court. Because, I mean, it still does not get the president to go and show up at the commission and to give that very important side of the story by him as the head of state.
Well, the judgment is clear. Justice Kampepe basically said in handing down her judgment that the court thought that there was absolutely no possibility that he would comply with going before the commission to answer the questions that have been posed to him. And bear in mind that he did appear at the commission twice, and on the second occasion left abruptly. And further to that, when this case was brought to the Constitutional Court, he and his lawyers were basically absent from there. So and if you take all of the public statements made by him through his foundation and other bodies associated with him, it was very clear that he had very little regard to the Constitutional Court, to the Commission itself, and would perhaps only listen to himself or his own advisors. So his contempt for the Constitutional Court moved beyond that of the Constitutional Court, but in fact to our entire democratic system, which he has now called into question as well. So the court simply said there is very little chance or no chance at all that he could be persuaded to go to the commission.
Well, now there's definitely no chance of him actually going to the commission at all. Will the commission then come out poorer because of that?
It will, but I guess it has ample amount of information to deal with all of the issues that it has had to do in terms of its brief. It will make its recommendations, minus the engagement with the former president. But I suppose that will be one of the limitations of the report when it comes out.
Professor Madonsela, your initial report is the report that, of course, got this particular commission going. The fact that now we are at this point where there is a committal order, a punitive committal order coming from the Constitutional Court, yet we are still not going to have the former president go to give evidence at the commission. What does that mean for the work of this commission and what will come out in the final report?
I agree with my colleague and you that, of course, this is not an ideal outcome. A best result from this commission is a story that includes President Zuma's own account. And you'll recall that the very reason I came up with a commission of inquiry was because I struggled to persuade President Zuma to give me his side of the story. He promised to do it on a number of occasions, and then eventually he then claimed that he wasn't given enough time, and now he's had more than enough time. He's found different reasons not to tell that side of the story. And that said, it's sad not only for us, also for him, because ultimately he and those who support him would like to know what exactly happened in his own words. But the commission has to conclude, has to tell us the story about whether or not President Zuma's family or President Zuma allowed the Guptas, his son, and companies belonging to the Guptas and his son to have unbridled power to control who got appointed and who got dismissed in cabinet posts and in SOEs, and whether this power was leveraged for state contracts, licensing, and even extended to interfering with the rule of law. The commission will have to give us answers to that. Since he expanded powers of the commission unlawfully, if I may say so, the commission now will tell us other stories about how much corruption is there in our system. And we've heard many stories to that effect.
Professor Madonsela, stay with us. Neeshan, I believe we do have to let you go. I appreciate your time, and thank you very much for joining us tonight here on In Focus. Neeshan Bolton will leave us. We'll continue in a moment with the former public protector, Professor Thuli Madonsela, when In Focus continues next as we unpack a little bit more coming out of that judgment tonight. Right, we're back with you now here on In Focus, and we continue with our conversation tonight on the ConCourt judgment on former President Jacob Zuma, with some reaction coming through from the former public protector, Professor Thuli Madonsela. Professor Madonsela, let's talk then about whether the commission had an alternative. Was there an alternative that the commission could have sought to coerce the former president to come to the commission? For example, many are citing the TRC and how the TRC sent subpoena after subpoena after subpoena to coerce the then president P.W. Botha to go and show up. Of course, he never showed up eventually, and a contempt order was found. But was there an alternative for the commission?
I don't think there was an alternative at this stage. You will recall that the first contempt order, contempt against the commission, was issued in December by the Constitutional Court. So President Zuma is not just in contempt of the Constitutional Court, he's in contempt of the State Capture Commission of Inquiry. And with this matter having now reached the Constitutional Court and him defying the highest court in the land, there was no other option. And it really is, it saddens me that it had to end this way, but I see no other way that the Constitutional Court could have resorted to.
Now, many in society tonight are questioning the constitutionality of a punitive committal order in a civil contempt matter. To say, well, it's a civil contempt matter, but he's being treated criminally. What does that mean for me, right? He's been detained without a trial, and so on and so forth. How do these things play out and read in society?
Well, but that's how contempt of order matters operate. Is we all know that if an institution has been given power to call you before it and to require you to answer questions, and if that institution has been given contempt powers, the failure to comply with that order will incur you a criminal committal. It is there in the Commission Act, and in the Commission Act, it talks about 6 months. But the people who are talking about this are the ones who should have advised former President Zuma to argue these matters. He was given an opportunity. You will remember that the Chief Justice bended over backwards and wrote a letter to President Zuma and said, kindly address me on sentencing. This should have been the time when those arguments should have been presented to the Constitutional Court.
In your view, the main judgment giving a 15-month prison sentence, while the lawyers, I think, for the commission had called for 2 years. I mean, did the majority court there navigate that balancing order properly?
Of course, this is one thing I can say is I cannot say that I would have arrived at the same decision, but as Lord Denning said, it is a reasonable decision by the Constitutional Court. It is a rational decision by the Constitutional Court. And in the circumstances, it sends a message across.
Yeah. Does it send the message across far enough, particularly when it comes to these scandalous remarks that keep coming towards the judiciary from not just the former president, but of course even others who are hearing what the former president is saying and in support of that and continue to make those remarks? Will this be a deterrent enough from people to continue insulting the judiciary?
Trust me, it will be a deterrent. People will think twice before they insult the judiciary. Trust me, I've seen from some quarters comments already, they're a little bit tempered. Because it really is not about whether we like those judges or not. We have a right not to like them or even to blatantly dislike them. We just have no right to undermine the rule of law, because the rule of law and justice are what holds a society together. When that crumbles, when people have no hope of being treated justly on an everyday justice basis, when people have no hope that courts of law that are trusted, that are above petty differences, that are impartial, are going to adjudicate their matter impartially, then not only the rule of law crumbles, democracy crumbles into pieces. And peace goes with it.
Yeah, it will move, it seems, now from the judiciary having made its decision, and of course the law is the law, and it is what it is, and that's what has come out to become almost now a political football. It is seemingly now moving into the political arena. What would it mean, really, for the former president to continue to defy this order? He's been given 5 days to go and present himself either to the Nkandla police station or to the Johannesburg Central police station. Those who support him are saying, well, they will have to drive over them to get to the former president.
Well, my hope is that for his own sake, President Zuma, for the sake of his party, for the sake of the work that was done by Oliver Tambo or by himself out there without an army, without a police force, without a judiciary in keeping the ANC alive, President Zuma will finally do the right thing and submit himself in dignity to the rule of law. We all at times don't like decisions that are made against us or about us. But part of the price we pay in living in a society is that we have to obey the rules of that society. And those rules apply to all of us, regardless of who we are. And they apply to President Zuma, and in the same way that they would have applied to an ordinary Koko Dlamini or Mr. Dlamini, who is a gardener or a domestic worker.
Yeah.
To those who support President Zuma, if they truly love him, they should ask him to submit himself in dignity to the rule of law and go to prison, which is sad. I personally am saddened by it, but I see that this was brought upon President Zuma by himself and his legal advisors.
The constitutionality of the punitive committal order is something that I suppose will be discussed for years to come. But when, of course, you touch the Constitution, many say, well, that's a sacrosanct document. That is the ultimate rule of law in the country. Coming out of this judgment, is the Constitution still intact?
The constitutionally is definitely still intact. In fact, better intact now, because during my term as Board Protector, the one thing that people had faith in about South Africa as a country was that the rule of law remained intact. And when people have been attacking the courts and some doing whatever they want to do, seemingly with impunity, people started worrying about whether the rule of law was holding in South Africa. So the decision today, sad as it may be at a personal level, it is an affirmation of the fact that our Constitution builds a solid ground for our democracy. And I must say, there is an option for President Zuma. If he truly feels that his human rights have been violated, he can approach the African Human Rights Court. He can also approach the international court system. Sadly, SADC leaders killed the SADC Court of Justice. So this would have been an opportunity for President Zuma to take his matter to the SADC court as well. So the Constitutional Court is the last port of call in the country, but it's not the last port of call in the world.
Former Public Protector, Professor Thuli Madonsela, we appreciate your time and thank you for your insight tonight here on In Focus. We'll continue.